Hey, my trendies, trendsetters, and my trendy tribe. Mic check, 1 2 1 2. Let me know if y'all can hear me. Sound check, just to make sure. Let me know, can y'all hear me? I see the thing vibrating. That's a good sign. Okay, thank you, Miss Main Event. Okay, so if you can see the banner, it says I'm just gonna get straight to the information on this one. And so we can get about our way because I'm not supposed to be live right now. Thank you, Demi. So let's go ahead and get started. Okay, let me see how this is lined up. How's this gonna go? Okay, let me make it a little smaller then. Y'all, all right. So as you saw in the title, Simon Guobadia was denied U.S. citizenship. This was, I think this was January 2024, and of course it just came out now. And I didn't see it on my radar either until it came out. Like it's going viral. So that's how I saw it, and I was able to see the court document where the order is issued that why he's denied the U.S. citizenship naturalization. Right. I was like, God, dog, y'all gonna stop listing stuff? So let's get into it. Let me show y'all what it says. So it's Simon Guobadia versus basically the Citizenship and Immigration Services, U.S. Citizenship and Immigration Services. All right. So the order, it says this matter appears before the court on respondents, henceforth USCIS motion to dismiss. For the following reasons, the court grants USCIS's motion and dismisses petitioner's case. All right. Background. The case arises out of petitioners, and petitioner will be Simon, petitioner's application for the U.S. citizenship and naturalization. USCIS denied petitioner's application on July 27, 2022. Petitioner requested a hearing on this decision, and the denial was reaffirmed. The court derives the following facts from petitioner's complaint and its attachments. So it was multiple times he's applied. we're getting down to the time that he got denied this last time. The case got dismissed this last time in January 2024. All right, so petitioner is a Nigerian citizen. Petitioner first entered the U.S. on August 11th, 1982. He overstayed his visitor visa, however, and in 1985, INS denied his application for adjustment of status. He was declared deportable and voluntarily departed from the U.S. on December 28, 1985. He then re-entered the United States in June 1986. Petitioner again overstayed his 6-month visitor visa. In September 1987, petitioner was arrested for bank and credit card fraud and pleaded guilty to a felony offense. He was arrested in January 1989 for unauthorized use of a vehicle and again in May 1990 for fraud. Thereafter, the agency began removal proceedings. In January 1991, petitioner committed another felony offense, credit card fraud. In April 1991, an immigration judge held a hearing and ordered petitioner be deported. On March 4, 1992, petitioner was deported and physically removed from the United States. Before his March 1992 removal, however, on October 24, 1988, petitioner used a different identity to seek temporary resident status under the Special Agricultural Worker Program, SAW. He also did not include his criminal history on his SAW application. When his SAW application was approved, with these misrepresentations and omissions, he was given a registration card as a temporary resident on July 25, 1991. As part of SAW immigration benefits, petitioner's temporary resident status was automatically converted to permanent resident status following the waiting period. Petitioner received his permanent residency card on April 27, 1992, 26 days after he had been deported under his other undisclosed identity. On December 22, 2016, petitioner applied for naturalization under his second identity and was denied because his temporary resident status was unlawfully granted. On December 31, 2020, petitioner filed another application for naturalization. Following an interview with petitioner, USCIS again denied petitioner's naturalization application. USCIS explained that he was ineligible because he had not been lawfully admitted for permanent residence. His temporary resident status achieved through the SAW program and benefits had been based on a different identity and disqualifying criminal inadmissibility that was willfully concealed. On October 24, 2022, petitioner requested a hearing on this decision, and USCIS reaffirmed the denial of his naturalization application on November 15, 2022. On March 13, 2023, petitioner filed an instant complaint in this court and asked the court to vacate the denial and remand the instructions to grant petitioner's application. Legal standard. A respondent may move to dismiss a complaint for failure to state a claim upon which relief may be granted. When considering a Rule 12b-6 motion to dismiss, the court accepts the factual allegations made in the complaint as true and construes them in the light most favorable to the petitioner. To state a plausible claim, a petitioner need only plead factual content that allows the court to draw the reasonable inference that the respondent is liable for the misconduct alleged. A complaint must contain either direct or inferential allegations respecting all the material elements necessary to sustain a recovery under some viable legal theory. A district court can generally consider exhibits attached to a complaint in ruling on a motion to dismiss. If the complaint's allegations conflict with an attached exhibit, the exhibit controls. So the exhibit, I'm taking that as the exhibit is the end all be all. A conclusory general allegation in the complaint might not suffice in the face of a specific material uncontroverted facts stated in an exhibit. The analysis. Petitioner's complaint asked this court to vacate the USCIS's decision denying his naturalization application and remand with instructions to grant his application. USCIS moved to dismiss petitioner's complaint because he has failed to assert a basis for the court to grant his naturalization application. Briefing on USCIS's motion to dismiss is complete, and thus the court must determine if petitioner has stated a claim that his naturalization application should be granted based on the information in his complaint and its attachments. As is relevant for petitioner's case, and if you're coming a little bit later, petitioner will be Simon. For USCIS to grant a naturalization application, the applicant must be lawfully admitted to the United States for permanent residence. It is the applicant's burden of proof to show that his entry to the United States was lawful. More specifically, the applicant must have been a lawful permanent resident for at least 5 years, reside in the U.S. continuously between his naturalization application and admission to citizenship, and be a, quote, person of good moral character, attached to the principles of the Constitution of the United States, and well disposed to the good order and happiness of the United States. Here, USCIS denied petitioner's application because he failed to show that he was a lawful permanent resident. Petitioner's permanent resident status arose from his application for SAW immigration benefits in 1992. The factual record, however, shows that petitioner's SAW application had been based on a number of misrepresentations and concealments by the petitioner. Specifically, petitioner applied for SAW benefits under a different identity. Also misrepresented his marital status. Also improperly answered no to the question of whether he had any prior arrests or convictions. Also incorrectly answered no to the question about whether there was any factual basis that made his inadmissible under 8 U.S.C. 1182 given his criminal history. And misstated the date of his last entry into the United States. Review of the petitioner's application following request for a hearing reaffirmed this decision and its reasoning. In this lawsuit requiring the court's de novo review of USCIS's decision, petitioner importantly does not dispute these factual findings. He does not contend that either USCIS's account of his testimony or the government records were incorrect. Instead, petitioner contends that USCIS misrepresented the significance of his misrepresentations on his application. The court treats the complaint's allegations and its attachments, which include the USCIS decisions, accordingly. Petitioner first argues that he should be granted naturalization because Immigration Services has not raised any concerns about petitioner's permanent resident status for 3 decades. Quote, indeed, until the petitioner's naturalization application, no immigration official has contended that he has anything but a personally, lawfully granted permanent resident status. Petitioner then argues that he should not be made to bear the burden of the government's mistakes. He argues that the appropriate remedy for the issues regarding the application would have been to terminate his temporary resident status, and he should not be denied naturalization now. Going down, the court finds petitioner's arguments to be unpersuasive. Preliminarily, the court rejects the suggestion that USCIS is at fault for not discovering petitioner's own misrepresentations and omissions. Petitioner, in essence, asked the court to allow USCIS's previous treatment of his immigration status to ratify his unlawfully obtained permanent residency. The court refuses to do so. To be sure, it is petitioner who unquestionably holds the statutorily imposed burden of proof to show his eligibility for naturalization. The court does not find that this burden is carried merely based on the agency's erroneous treatment of petitioner's status following his own misrepresentations and concealments. Moreover, petitioner lacks any legal support for his argument that as an operation of law, he achieved lawful permanent resident status by the agency not previously having corrected his status, which again was only granted given his own misrepresentations and omissions. To the contrary, legal authorities suggest that achieving permanent residence through an unlawful means is a basis for denying naturalization. An application for permanent residence containing material misinformation fails to conform to substantive legal requirements. A naturalization petition was denied properly because the application for permanent residence misrepresented critical facts. Okay. This part, they're quoting other cases, and it says, affirming a district court's decision to revoke citizenship based on findings that the petitioner had not gained lawful admittance to the U.S., which was a statutory condition precedent to naturalization, and that if naturalization is procured by concealment of a material fact or by willful misrepresentation, it must be revoked. Thus, the court rejects petitioner's argument that he, in fact, is a lawful permanent resident based on his SAW application. Petitioner also argues that statements in his SAW application, whether fraudulent or not, cannot be used against him to deny immigration benefits because of statutory confidentiality protections afforded to SAW applications. The court concludes that petitioner's argument misses the mark. USCIS did not deny petitioner's naturalization application based on protected information in his SAW application. USCIS denied his application based on its own investigation during petitioner's naturalization application process. Not only does this investigation provide an independent source for this information outside the SAW application itself, but federal regulations allow for using prior immigration records in the process of assessing a naturalization application. Information contained in granted legalization files may be used on a naturalization application submitted by the applicant. Information contained in granted files may be used by the service at a later date to make a decision on a naturalization application submitted by the applicant. Hence, USCIS's decision did not improperly implicate any confidential information protected under statute, and the information contained in the SAW application can be used instantly to assess if petitioner states a claim for naturalization. Based on petitioner's complaint and the attachments therein, the court concludes that A, petitioner's permanent residency for purposes of his naturalization application depends on his permanent residency status achieved from his SAW benefits, and B, petitioner achieved his SAW benefits through misrepresentations and omissions regarding his identity, criminal history, and other personal characteristics, and C, thereby petitioner's permanent residency status is not lawful for purposes of granting his application for naturalization. Without lawful permanent residency status, petitioner's complaint fails to state a claim that he meets the eligibility requirements for naturalization. Conclusion. For the foregoing reasons, the court grants USCIS's motion to dismiss and dismisses petitioner's case. Petitioner would be Simon. It is so ordered this 11th day of January 2024. So I just want to say this. If y'all, I know more is going to come out because Tisa Tales was on Simon's behind either 1 year or 2 years ago. It was about how the house, they didn't pay for that. Not, I won't say they, but Simon didn't pay for that house right that he had. I think it was the house maybe after filing. It was some crazy stuff going on. Then where they were vacationing, it was some crazy stuff about where that place was and like how it was used to front, like, you know how people get on those fake planes to act like they flying private. It was like one of those types of places, but it's to fake like you live like that for real. I don't know, but Tisa Tales was on day behind. Now I got to go back and refresh my memory on some things, and I've been waiting to see, because I was telling Peaceful Journey, I was like, I've been scared for Porsha quitting her jobs because this man's stuff keep coming up like it's sounding real scam. It's sounding real scammer. So I don't know. But that's what most people are talking about. That's what I could see for myself, at least. Yes, Trish, you know, Tisa Tales been on his behind. She did not let up. Okay, so we got to go back. If y'all end up going over there to refresh your memories, just let her know I told y'all to come over there though, okay? Because for real, like, she was the reason I knew so much about Simon's behind the scenes stuff. All right, but I know that Tea Talk with your girl, I think she's gonna be live in about 4 minutes, so I'm not gonna stick around here too long. But thank y'all for coming to check out the document, because that's what it was. That's what the paper said. I will see y'all soon. Oh, you're a tattletale. All right, y'all. I'll see you soon. Thank you for stopping in. Bye.
I've been taking my time, I've been taking my time. Taking all of your time, taking all of your time, yeah. I've been taking my time, I've been taking my time, yeah. Taking all of your time, taking all of your